In episode 21 of the BoormanLawyers Court Reports, we appeared at Campbelltown Local Court in Western Sydney, where we appeared on an application to quash a habitual traffic offender declaration.
Yeah. Honestly, I think that 24/7 an understatement to my day-to-day. If ain't no way, then I'ma make a way. They say it ain't no way. I ain't never listened, kept them at the distance. This is for the ones who ain't afraid. And this is more than some paper chase. I wonder who else could say the same.
G'day, it's Josh Boorman from BoormanLawyers. Today I've just come out of Campbelltown Local Court, which is the court behind me. I've appeared for a client of mine who was seeking to have their habitual traffic offender application quashed. Now, just for everyone's information, if a person in New South Wales has been charged with 3 or more major traffic offences and have been convicted, or at least received Section 10s, for 3 major traffic offences within a 5-year period, then the RMS will declare them as a habitual traffic offender. Now what that means is that once they serve out their court-ordered disqualification period and they think it's time to go back and get their licence back, the RMS will actually then go and apply a further 5 years disqualification to their licence. So this is pretty extreme sort of penalties, and usually disproportionate to the level of offending that someone's been involved with. So what we did is we put an application on, and I might add that the habitual traffic offender declaration can be quashed by the court system. So it's up to a magistrate to decide whether that additional 5-year declaration be taken away or whether it should be left put in place. So our client was a habitual traffic offender. She had incurred 3 major traffic offences. One was a special range PCA offence, another was a disqualified driving, and the final third offence was a middle range PCA, which occurred in the middle of last year. So she was deemed a habitual traffic offender, which added 5 years on to her licence disqualification. So what we had to do is she's now served out the disqualification period for her last offence. We put an application onto the court to have the habitual traffic offender declaration quashed. We appeared before the magistrate today and gave some pretty persuasive submissions as to why our client has changed, how she's grown up, how she's matured over the past year that she has been off the road, and also the difficulties that she has incurred without a driver's licence. So we presented that all before the court. We put before the court some good character references and a letter of apology and reflection from our client. This was all taken into high regard. The magistrate was very receptive, and he agreed with our submissions that the 5 years additional habitual traffic offender declaration was very disproportionate to her previous offending, especially considering that she is not reoffended at any time during the period that she was off the road from the court-ordered disqualification put in place last year. So the magistrate was happy to quash the habitual traffic offender declaration, which means that our client can now take that court order along to the RMS, Road Transport Department, and apply for a licence to get back on the road. Keeping in mind that she is going to be subject to mandatory interlock laws because her last drink driving offence last year was a second drink driving offence. So it does mean that she can now go along to the RMS, have the 5-year habitual traffic offender declaration quashed, and now commence her minimum 2-year interlock period. But our client's very happy because she's just grateful that she can commence driving again and move forward in her life, having learnt some significant and major lessons. So guys, this is just another sort of matter that we've appeared on, a New South Wales traffic matter. Habitual traffic offender declarations will automatically be put in place for any person who has incurred 3 major traffic offences or more within a 5-year period. And as mentioned, it's really up to the court to take away that habitual traffic offender declaration and quash it. And that's exactly what we did here today. We applied to have that quashed, and we were successful in having that done. So our client was very happy. And if you found yourself where you've been charged with a drink or drug driving offence, or if you've got some sort of issue such as the matter which I've discussed today, where you've been declared a habitual traffic offender, then we can do certain things to minimise your disqualification or have these declarations quashed and get you back on the road sooner. Feel free to contact me on 1300 941 900. Or alternatively, go along to our website, which is BoormanLawyers, BOORMAN, lawyers.com.au. There's a heap of information there that we've published surrounding laws, penalties, offences, issues to do with habitual traffic offender declarations. There's videos, blog posts, statistics. There's a heap of information there surrounding traffic law in New South Wales, which you can read up on and make yourself familiar with. And have a bit more of an idea of what situation you could find yourself in. But by all means, give me a call if you want to discuss your matter further and see what we can do for you in court. Thanks for tuning in today, guys.